Hello, my name is Melissa Worth and I am a solicitor helping businesses and individuals to resolve their commercial disputes. Here I am again with another weekly law update. For those of you that have been following my weekly law review, you will have seen that I've chosen a couple of cases which demonstrate just how crucial it is to get the preparation of witness evidence correct. Continuing with this theme, I have chosen the case of PJSC Tatneft and Bogolyubov and others, which is a 2020 case, and the citation is EWHC 3250. The court has strict deadlines to trial, and the court is often extremely reluctant to extend them, especially if by doing so will compromise the trial date. In this case, the claimant sought permission from the High Court to submit further witness evidence after the trial had already started. The claimant wanted to rely on a further witness statement of Ms. Savalova, an in-house lawyer at the claimant company. Ms. Savalova was the head of legal in the Strategic Planning Department. The claimant submitted that she had been involved in the day-to-day issues which had led to the proceedings. In the application, the claimant argued that Ms. Savalova had not previously submitted witness evidence, despite her involvement, because she had concerns about her personal safety. However, having followed the trial online, Ms. Savalova decided that she was now prepared to give a statement despite her concerns, because she wished to challenge submissions made by the defendant that she and the claimant had acted in bad faith by deliberately failing to provide evidence. Ms. Savalova was therefore concerned about her own and the claimant's reputation. The deadline for submitting witness statements had passed 6 months before the trial had started. Civil Procedure Rule 32.10 states that if a witness statement or witness summary for use at trial is not served in respect of an intended witness within the time specified by the court, then the witness may not be called to give oral evidence unless the court gives permission. The claimant therefore needed to apply to court for relief from sanction, the sanction being that Ms. Savalova was not allowed to give her oral evidence. An application pursuant to CPR 3.9 was required for relief from sanctions. This provides that the court is required to consider all of the circumstances of the case when looking to grant relief, including the requirement that litigation is conducted efficiently and to enforce compliance of court rules, directions and orders. Applying the case of Denton and White, the judge determined that the claimant's breach was serious and significant. The judge also noted that Ms. Savalova's concern about her personal safety had not been raised before. In this respect, the judge noted that the proceedings had been ongoing since 2016. The judge also decided that, in all the circumstances, the application could not be justified, though Ms. Savalova's witness statement was likely to be supportive of the claimant's case. The defendant would be prejudiced because of the time required to prepare for the cross-examination. Further, Ms. Savalova's evidence would not address a new issue which had arisen during the trial. The application was therefore dismissed. As I stated, this case is another which highlights how important it is to thoroughly consider what evidence is required at the earliest possible opportunity and well before trial. If a witness doesn't give evidence, adverse inferences may be drawn. The judge stated in this case that, as a highly experienced legal team, the claimant's legal team knew there was a risk of an adverse inference being drawn. This is a common feature of commercial litigation, said the judge. Litigation is unpredictable, and it is not unusual for a party to determine that issues ought to or could be addressed after witness statements have already been exchanged. It is possible for a party to submit further evidence out of time, but the longer it is left, the higher the risk that the court will refuse relief from sanctions. As stated previously, it is crucially important to consider witness statements carefully at the outset and to keep the position under constant review. If you have any queries about this case, please do get in touch. And if you would like to review my earlier vlogs, please visit my YouTube channel by searching for Melissa Worth, Dispute Advisor. Many thanks.